My name is Michael Johnston. I am a citizen and a barrister at law, and as often as my clients' cases and causes permit, I am a jury lawyer. Before speaking about Bill C75 and jury selection, I did just want to take a moment to thank you for extending to me this incredible democratic opportunity. Not every country gives its citizens a voice in the legislative process. Not every political system is prepared to hear evidence that may call into question the wisdom of a proposed course of legislative action. Providing citizens with a voice and providing citizens an opportunity to be meaningfully involved in acts of government bespeaks a vibrant democracy. In spirit, Bill C75 seeks to give citizens more of a voice. Bill C75 seeks to put more citizens in the jury box, to have more citizens involved. And insofar as that spirit is in Bill C75, it's to be acknowledged and celebrated. However, it takes more than good intentions to make good legislation. I think we all know that there's a saying about where good intentions alone might sometimes take you. Bill C75's measures with respect to jury selection seem a bit perfunctory. They require, from my respectful submission, greater deliberation, greater calibration to achieve the stated objective, and most importantly, in some cases, outright elimination. Because if you're going to do something, have evidence that there's a problem and have evidence that this is going to achieve the solution. Trial by jury needs to be better understood in terms of how the provinces and the federal government interplay to achieve a representative jury role. There needs to be a better understanding of how challenge for cause informs and works with peremptory challenges. Ultimately, trial by jury isn't something that just happened overnight. Trial by jury started in many ways before the Norman Conquest with trial by compurgation. Over 1,000 years, trial procedure has slowly evolved through trial and error. The provisions that have persisted over time, I would suggest to you, aren't there just as historical vestiges, but stand the testaments of time. Bill C75, with respect to jury selection, comes along 48 days after the government's very public declaration of disagreement with the verdict. 48 days to study provisions and otherwise come up with solutions. From my most respectful perspective, it simply isn't enough time. As a result, in my respectful submission, much of what Bill C75 proposes in terms of jury selection is a legislative rush to judgment. And while the bill lacks a rational connection between its noble objectives and its actual measures, there are some things that can be nevertheless advanced here today, in my most humble opinion. We know that there is unfortunately a great problem and a tragic problem of overrepresentation of Aboriginal people in our criminal justice system. Now, correspondingly, there's underrepresentation in the jury boxes. Well, what is the correlation there? Criminal records. Criminal records are used to exclude citizens, tax-paying citizens, citizens that have a right to vote in federal and provincial elections. Criminal records that doesn't disqualify them from those civic responsibilities and duties, disqualifies them from sitting on a jury. Now, 3.8 million Canadians have a criminal record, or up to 3.8 million Canadians have a criminal record. Criminal records, both by the province and by the federal government, are used to exclude up to 10% of the population. Now, if Bill C75 wants to rid itself of discrimination in the jury selection process, this is the lowest hanging legislative fruit. Get rid of criminal records as a vector for excluding citizens, and if you want to exclude citizens because you think they're biased, produce the evidence. We have provisions already in place to deal with that under 638(1)B of the Challenge for Cause provisions. And that being said, Bill C75 is noble in its spirit. It already contemplates modifying 638(1)C to narrow the exception. It wants people that have gone to jail but served only 1 year of jail to be eligible for jury duty, changing it, obviously, from the 1 year that it currently is to 2 years. So Parliament wants people with criminal records to be involved. It wants to give these people a voice. But remember what I said about this interplay between the provinces and the federal government. Well, unfortunately, Parliament's intention to have people with a criminal record who, for example, have served 1 year in an institution is going to be frustrated by the fact that almost every province excludes people with a criminal record for much lower reasons. Like in Ontario, if you've been convicted of an offense that was prosecutable by indictment, that leads to automatic exclusion. So that's easy areas for the government to come in and to create a basis whereby it says across the country you can only be excluded for this reason. Justice Iacobucci in his report actually appreciated the interplay between the two levels of government and made a recommendation that I submit to you. You can adopt and take one small step further. I'm suggesting that 626 of the Criminal Code say that nobody in Canada or no citizen is subject to exclusion from jury duty merely because of a criminal record, or simply to say that the criminal record exclusion should parallel that of the federal government. They did that with respect to when provinces were excluding spouses of, let's say, doctors or other people that were otherwise ineligible. I'm almost at the end of my time, I appreciate. I have two other areas that I did just want to briefly address, and most importantly, I want to speak about challenge for cause. Section 640 of the Criminal Code. This is a small little provision that has otherwise been tucked away in this omnibus provision, and perhaps not many people have even spoken about it. But this is a criminal law provision that has existed in its almost exact form since 1892. Jurors that are either unsworn or sworn have been entrusted to decide if a challenge for cause is true. Now, this is also important in terms of giving citizens a voice and encouraging citizen involvement. Jurors pick themselves. When they ultimately determine that a juror can sit on a jury, the jury that ends up sitting is a reflection of the choices of the litigants and the jurors themselves. This litigation proposes, this piece of legislation proposes to have judges completely overhaul that situation and be the sole people to make that determination. There's no evidence that there was ever a problem with this challenge for cause procedure. There's no evidence that this is going to actually provide any form of meaningful solution, even to expedite matters at all. In my most respectful submission, there is no good reason to interfere with the challenge for cause procedures. They fulfill a very important role in terms of ensuring a defendant to whom the right to trial for jury exists, that their body is an independent, impartial, and representative one. I would most respectfully submit that this idea to change the challenge for cause procedures is totally unsubstantiated and without merit and should be eliminated, unless there's some reason for it offered in terms of let's continue on with 640 being modified. Finally, I'm not sure how much time I have left. I think
2 more minutes.
Oh, very fair. Thank you, sir. I did want to say something about peremptory challenges. As a jury lawyer, I'm somebody who is often in the situation where I'm facing unrepresentative jury pools or jury panels. There are many situations. Most recently, I ran a 4-week judge and jury trial where my client was an Ethiopian Muslim, and his co-accused was a Muslim. There was not many blacks or Muslims on Ottawa's jury panel, I assure you. We had to exercise almost to the full extent of our abilities the challenge for cause and the peremptory challenges in order to get the 12th juror, who was the only racialized or visibly racialized juror. I say that because peremptory challenges are important to protect the rights of the accused, and that's often what seems to be lost in all of this conversation, that trial by jury is a benefit that exists for the accused person. There are 2 reports that have been cited by the Ministry of the Attorney General when this legislation was tabled, seeking to justify this legislation. But as a lawyer, I always like to go and look at the actual source. And I just commend to you to go and look at the Manitoba Inquiry Report, which is being cited as the basis for this removal. Now, in 1991, it was suggested that these peremptory challenges should be eradicated because of the discrimination that they allowed. But at the time, it also made an additional recommendation. The additional recommendation was to change the way in which juries are selected so there could be some greater questioning of potential jurors. You can't just nitpick And I respectfully ask this committee to consider that if you are going to go so far as eliminating peremptory challenges, and I would say that Justice Iacobucci, when he studied this in 2013, came to a nonpartisan and determined and decided conclusion that it was good to keep them, but to provide some oversight by way of something akin to an American-style Batson challenge. I'm sure I've exceeded my time at this point, but I'm happy to answer any and all questions with respect to jury selection or anything else. I thank you kindly.
Thank you very much, Mr. Johnston. So we're going to move to questions. Mr. McKenzie?
Thank you, Chair, and thank you to the panel for being here today. And I found all of your opening remarks were remarkable because I think they hit the nail on the head for most of what we've been hearing for the last few days. And Mr. Johnston, you mentioned one issue, one trial that turned out to be controversial, perhaps because of the jury pool. And we also recognize that that was not a long time ago. So to make the massive changes that we're trying to make, I think you're right that it does take a whole lot more research and looking into fixing the problem rather than addressing it in a quick manner. And I think that's where you're coming from, your comments. Would I be right in that you believe it needs to be changed, but we need to spend some time to do it?
We absolutely need to calibrate the system. At all times, a system such as our trial by jury system requires modernization, and it requires analysis to ensure that it's achieving what it's supposed to achieve. But of course we need a better understanding of it. It's been since 1980 when the Law Reform Commission made a comprehensive study of this. And we need a nonpartisan understanding of trial by jury, because trial by jury, while it exists in our democracy, isn't informed by democratic decisions. It's not subject to, let's say, public opinion. In fact, it's supposed to guard against the exact opposite. So I very much agree with you. We need a nonpartisan understanding of the system before we start pulling planks away.
Sometimes common sense seems to be lacking. And, it's more important that we do things in a hurry at this place. But I think you're absolutely right. We need to take our time and do it right as opposed to making wholesale changes in a hurry.
I agree, sir.